College. I welcome you all on day 2 of this online workshop for non-teaching staff. To further the proceedings, may I call upon Dr. Vinita Tuli to formally welcome the guest speaker for the day, Dr. Rohan Rai. Dr.
Thank you, Manika. I, Dr. Vinita Tuli, Coordinator IQAC, on behalf of the College and Internal Quality Assurance Cell of Atmaram Sanatan Dharm College, welcome Dr. Rohan Rai, Joint Registrar Establishment, to this 3-day online workshop organized by the IQAC. Sir, we are really honored to have you with us, and we are really glad that you took out time from your busy schedule to be with us and talk on this relevant topic on facets of administration in university and colleges. I welcome you again, sir. Over to you, Manika.
Thank you, Vinita. Let me introduce our guest speaker to the audience. Born and brought up in Varanasi, Dr. Rohan Rai completed his school education in Varanasi and joined Banaras Hindu University for his higher studies. He obtained a doctorate in management from the same university. While pursuing his PhD, he was selected as the Assistant Registrar in the BHU in September 2004. During his tenure in BHU, he worked with various institutes managing faculty and central administration of the university. In 2012, he was selected as Deputy Registrar in HNB Garhwal University, Srinagar, Uttarakhand, where during his brief stay, he handled the teaching and non-teaching establishment. He joined the University of Delhi as Deputy Registrar on deputation in May 2013 and was appointed on permanent post in July 2015. In University of Delhi, he has handled the estate, scholarship, finance, council, and academic branches. Currently, he is the Joint Registrar of Establishment, Teaching and Non-Teaching, and Desk Sections. I welcome you, sir. I now call upon sir to deliberate on the topic facets of administration in university and colleges. Sir, the dais is all yours.
Thank you, ma'am, for your kind welcome. The topic pertains to the administrative work that the non-teaching staff especially and the teachers also who are involved with the administration in university and colleges deal with these some of the topics that they deal with during their day-to-day administration. I am trying to deal with that. This is the I will start with this presentation. The facets in what are the facets that we are going to talk to the people today includes admission, rosters, recruitment, promotion, seniority, leave, LTC, and disciplinary matters. Though the list is quite long, but I assure you that I will not bore you with all the details. I will be just trying to deal with some of the aspects that the day-to-day administration deals with while functioning in the university or in the college. So first we start with the admission. So the most important work in the university or its college is that we have to admit students for which we are established, and we are the existence of the institution that we work with is because of the students. So we the most important administrative job that a college or a university functions is to take admission of students. So what are the themes that we will be discussing today about admission of students? First is provisions of ordinances governing eligibility, readmission, migration, span period. See, these topics that I have chosen are the according to me most relevant, and I feel that once we have dealt with all these things, the audience will also understand that these are the day-to-day issues that crop up with the function in the functioning. So in admission of students, first we are dealing with what are the ordinances that provide for admission of student, how the eligibility, their readmission, migration and span period. Then I will deal with certain aspects that what are the relaxations and concessions that are prescribed in the admission process, and the most important and the latest the Academic Council resolution regarding the ward quota for admission of the wards of the university and college employees. So the first one is the Ordinance 1 of the ordinances of the university, which deals with the qualifications for admission. And what it provides for: no person shall be eligible for admission to the university unless he or she has passed the intermediate examination of an Indian university or the higher secondary examination of the Board of Higher Secondary Education, Delhi, or an examination recognized as equivalent to either of these examinations by the Academic Council from time to time, and possess such other qualifications as may be prescribed by the ordinances. So the first point is, for admission in undergraduate courses, any person who has passed the intermediate examination of whatever state board or CBSE or whatever board, the list of boards is in all at the start of the academic admission process or during the bulletin, when the bulletin of information is released, the university or the admission branch of the university issues a list of boards that are recognized. And even though if somebody comes with some other board which is not in the list, the university has a procedure in which that they decide whether that board can be considered as eligible, and the candidate passing through that board, the intermediate or equivalent examination, should be admitted. So the first eligibility is that the person has to pass the intermediate examination or equivalent level examination. Second important point is that there is no minimum age bar for taking admission in an undergraduate course. For that matter, now the bar in the postgraduate courses also has been removed. Earlier, the persons who are associated with the college or the university for a long period of time may understand that there was a provision, I think in 2004, 2006, that the minimum eligibility for taking admission, minimum age for taking admission in undergraduate was 16 years, and for that matter 20 years or 21 years in postgraduate courses. And there was a provision where the vice chancellor can relax that minimum age bar up to a level, up to 1 year. And some of the cases that we are still dealing with. But after 2006, I think the AC in 2006 or 2008, I'm not sure, passed a resolution where the minimum age bar was removed. So now what is the provision? It is no minimum age bar for admission to undergraduate courses and postgraduate courses in the university and its colleges, except in professional courses where regulatory body has prescribed minimum age requirement. This is, there is a provision that there are certain courses that the university runs or offers, and those courses are where the regulatory body is different from the university, just like MBBS course or B.Ed course, for which the regulatory body is NCT. For MBBS, it is the Medical Council, and the LLB course where the governing regulatory body is Bar Council of India. And these in these courses, if these regulatory bodies has prescribed any minimum age or maximum age, then that is applied. Otherwise, all the courses offered, whether at the UG level or PG level, by the university and its colleges, there is no minimum age bar. Like we discussed in the first point, how a person is eligible for admission in undergraduate courses. Now, in the postgraduate courses. No person not already being a member of the university shall be admitted to any postgraduate course unless he has passed an examination recognized as equivalent to a degree examination of the university. So for being eligible to be admitted in a postgraduate course of the university, the candidate or the applicant needs to be a graduate. The candidate seeking admission to a course of study in the university must satisfy the rules and conditions made in this PIA. Whatever we have discussed up till now, 3 points, these are only the minimum eligibility that makes an applicant eligible for admission. But the different courses of the university being offered at the undergraduate and postgraduate level, they have certain other criteria or eligibility qualifications or conditions that must be met by the candidates to be admitted. Now, this is the what you call the most important points in the admission part. The other ordinances deal with like the ordinance 2 deals with the courses admission committee. There is a provision of courses admission. Whatever courses are being run, there is a courses admission committee, and they formulate the procedure of admission, the qualifications of the admission, the eligibility criteria, and so forth. So in academic or admission related things that we are going to talk about, we now move to Ordinance 4, which deals with migration and readmission. These are the two important things in a sense that because of these provisions, the both the non-teaching staff and the teachers of the colleges get applications from candidates who want to move from one college, from their college to some other college, or from some other college to their college. So what are the provisions that we will be dealing with? Inter-university migration may be permitted only in the beginning of the third semester of only the BA program and BCom program under semester mode on production of leaving certificate from the principal of the college or from the registrar of the university she is leaving, and mark sheets of the examinations already passed and documentary evidences in support of the ground on which migration has been sought. This inter-university migration means that a person studying in some other university wants to migrate to the University of Delhi. And in this, the Ordinance 4 provides for there are only 2 courses where this provision is made, that is BA program and BCom program, and under 3 conditions. What are the 3 conditions? First is leaving certificate from the principal of the college or from the registrar of the university. The student has studied the first year. Then mark sheets of the examinations already passed, that is the first semester and second semester, or yearly basis, then the yearly mark sheet, first year mark sheet. Then third is the documentary evidences in support of the ground on which migration has been sought. So the applicant has to submit a documentary evidence why he wants to migrate from University A or B or C, whatever, to the University of Delhi. The other provision of this ordinance or provision is provided that such a student will have to pass all the papers of the first and second semester examinations of the said course of the university. Though we ask for the mark sheet of the examinations passed, and there might be a condition that the candidate has passed all the examinations, but the ordinance provides for that the student or the applicant, once migrated, has to pass all the papers of the first semester and second semester of the university course or the university syllabus or what is there. Provided further that their marks shall be proportionately upgraded in the first and second semester examinations in the absence of internal assessment marks. In case of internal assessment marks, there is a provision that the marks will be proportionately upgraded. This And one other condition is that admission of a student to the university in the third semester of study for BA, BCom degree examination may only be allowed on the ground that the parent or guardian of the student is residing in or has migrated to Delhi. There was a condition that the application must have documentary evidences in support of the ground on which migration has been sought. That ground has been defined in point number 2, which says that degree examination, this migration will be allowed on the ground that the parent or guardian of the student is has been residing in Delhi or has migrated to Delhi. Though with the onset of choice-based credit system and now the upcoming new education policy, the provisions are that the students have got choices to study courses from different university and different colleges of their choices. So, but in view of this ordinance, existing ordinance, when the NEP will be implemented, the university may seek to form a rule or regulation how much students that we can admit from other universities and how that procedure needs to be established, and that would be done. Now it comes the inter-college migration, which is most common in our university, and it is also under the provision of Ordinance 4. Inter-college migration within the University of Delhi in the third semester of BA, BCom, BSc, BA Honors, BCom Honors, BSc Honors courses under the semester mode may be allowed subject to availability of seats and consent of principals of both the colleges. This provides for the inter-college migration in all the courses being offered under semester mode. Earlier, the SOL, the courses offered at undergraduate level in the SOL were on yearly basis, and last year, the semester mode was introduced in SOL also. So now the applicant seeking admission, migration under this provision to regular colleges from SOL has increased. This proviso does not allow inter-university migration to second professional of BAMS, that is Bachelor of Ayurveda, Unani medicine, homeopathic medicine. Then the other provision is inter-college migration will not be allowed at the postgraduate level. So there is no inter-college migration allowed at the postgraduate level. The last date for migration will be 31st August. This is the provision that was made in the Ordinance 4, I think in 2012, and it has continued. Last year, because of the pandemic situation, it was first increased to 30th September and then to 7th October. And I think this year also it was extended by the Vice Chancellor, and the same was later on approved and reported into the Academic Council. But the ordinance provides for that the last date of inter-college migration will be 31st August. How this will be done? Applications for migration from one college of the university to another shall only be entertained by the principal if forwarded by the principal of the college from which migration is sought, and the necessary alteration in the enrollment entry shall only be made in the university register by the registrar after obtaining the consent in writing of both principals. So as per the provisions of ordinance, this inter-college migration does not involve the approval or does not require the approval of the university. However, the earlier migration that we discussed, that is inter-university migration, in this case, the inter-university migration, the college will receive an application and prepare the application and submit the case to the university, on which the university will approve, and then the inter-university migration is done and the student or the applicant is admitted. But in case of inter-college migration, it is between the two colleges, and the principal of the college in which the student or applicant has studied the first year should write or give an NOC that he has no objection if the candidate moves to X college, and the college where the candidate is going, the principal of that college has to give an NOC that I have no objection that this student is admitted in the third semester. So this, in the inter-college migration, no need for approval of the university. Now, there are certain provisions for readmission of these students. What are those? A student of the university having failed to pass any examination of the university will be registered as an ex-student for appearing in the said examination, subject to the conditions laid down under the regulations of the university relating to conditions of admission to university examination. So, if a person who has not passed any examination of the university, like a applicant admitted in the first semester of an undergraduate course, appears in the papers, and first year he doesn't pass any of the paper, then he will become an ex-student. A student of the university who was not allowed to appear in the examination due to shortage of attendance will be readmitted to the class he studied last in his college department within the prescribed period of registration. If a student is debarred from appearing in the examination, then he will be admitted again in the same class where he was studying. If a student's name is struck off the rolls of his college, he may be readmitted to the same class at the discretion of his principal in the same academic year or within the period of registration if readmission is sought in any subsequent year. No enrollment fee will be charged in such a case, and a remark in the university register shall be deemed as equivalent to fresh enrollment. So there is a provision that if somebody has not appeared, not taken classes and wants to get readmitted in the same class, the principal can do that. But the only thing is, if this is done, the readmission is done, then the span period that we will discuss later will remain the same from the date it was the original admission. Now, there is no change of subjects allowed, whether in optional or elective subjects. So, no change in the optional or elective subjects or subsidiary subjects in any semester of the postgraduate or undergraduate courses is permitted, either in UG or PG. No change of subject is allowed. Once you are admitted in a particular course, the subjects offered in that course are taken by you, and there would not be any change in the subjects that you have opted for. Now, what are the relaxations and concessions for admission? There are some relaxations for scheduled caste and scheduled tribe. What is it? The minimum eligibility for admission to postgraduate courses will be the minimum pass marks of the qualifying examination concerned of the University of Delhi. And the minimum eligibility requirement for the scheduled caste and scheduled tribe candidates will be that they must have passed the qualifying school or degree examination. Up till this academic session, we have been doing admission based on cutoff in undergraduate, and as you all know, the separate cutoffs are issued for separate category of candidates, and anyone meeting that cutoff is getting admitted. But the minimum eligibility requirement for undergraduate is the passing marks in the qualifying school or degree examination, and for that in the PG, it is the minimum pass marks of the qualifying examination concerned of the University of Delhi. In case the scheduled caste or scheduled tribe candidates had passed the last qualifying examination from other universities, they should have secured at least the same, So in such scenario, what we have to ensure is that their passing marks is the same as that is for that particular course in the University of Delhi. Then only they be allowed to admit in PG courses. Wherever the entrance examination is there, they have to be the scheduled caste and scheduled tribe candidates will also appear in the entrance exam, and their merit list will be drawn separately, as we do for admission in PG courses or 8 or 9 undergraduate courses up till now, in which we are having admissions based on entrance examination. For MPhil and PhD, the SC/ST candidate shall be given 5% relaxation in minimum eligibility marks. Now, the other concession that is being given is to the candidates belonging to other backward classes, that too other backward classes and who belong to non-creamy layer. The OBC candidate shall be given a relaxation in the minimum eligibility in the qualifying examination and the minimum eligibility, if any, in the admission entrance test to the extent of 10% of the minimum eligibility marks prescribed for the category candidates. Since in practice we are not defining the minimum eligibility marks prescribed for the entrance test in case of general candidates, the practice in the university is to prepare a merit list of OBC candidates, as we are preparing the merit list for SC candidates and ST candidates. All those OBC candidates who meet the minimum eligibility marks in the qualifying examination and the minimum eligibility marks, if any, in the entrance test shall be eligible for admission in the order of their merit. And which OBC candidates are allowed to get this concession? The OBC candidates who belong to the non-creamy layer and whose castes appear in the central list of the OBCs. That is most important. So in certain castes are mentioned as OBC in different states, and they change from state to state. So University of Delhi, being a central university, has decided that the OBC candidates who belong to non-creamy layer and their caste must be in the central list of the government, not in a particular state list. Then there is concession for persons with disabilities. Now it has become persons with benchmark disabilities, which is 40% disability, and they must have a certificate, and 5% relaxation is to be given in the eligibility in qualifying examination or minimum eligibility. Then the government of the University of Delhi extends this 5% relaxation in minimum eligibility requirement to the children and widows of the armed forces personnel, which we commonly know as CW category. The university also extends the concessional fee admission form or entrance examination fee to the candidates belonging to scheduled caste, scheduled tribe, and persons with benchmark disabilities. Then the reservation is for scheduled caste, it is 15%, scheduled tribe 7.5%, other backward classes, non-creamy layer 27%. The seats reserved for SC/ST is to be filled by SC/ST, and the seats reserved for OBC has to be filled by the OBC candidates only. Apart from that, we also admit students under some supernumerary seats. What are those? First is persons with benchmark disabilities, not less than 5% of total intake. That is, if the total intake is 60, then the persons with benchmark disabilities, at least not more than 3 applicants under this category may be admitted. Earlier it used to be 3%, now it has been enhanced to 5% in view of the Rights of Persons with Disabilities Act 2016. Then For the other supernumerary seats include children, widows of the eligible armed forces personnel, that is CW category, and this is 5% of the seats in each course. Now, what are the candidates that are eligible under CW category? The Academic Council has approved the following guidelines, which includes the candidates belonging to CW category has to get an educational concession certificate. In the next slide, I'll deal with who are eligible to issue such certificates, and they are to be clubbed under different priority, and their admission is done as inter se priority. And what are those priorities as approved by the Academic Council? Priority 1 is the widows wards of defense personnel killed in action. Priority 2 is defense personnel disabled in action and boarded out from service with disability attributable to military service. Third is defense personnel who died while in service with death attributable to military service. Fourth is personnel disabled in service and boarded out with disability attributable to military service. Then priority 5 includes wards of ex-servicemen and serving personnel, including personnel of police forces who are in receipt of gallantry award. Again, these gallantry awards are as per inter se priority. That is, a candidate with gallantry award of Paramveer Chakra is to be treated on priority than a candidate with a gallantry award of Ashok Chakra or Mahavir Chakra or Kirti Chakra. So what are the gallantry awards? Paramveer Chakra, Ashok Chakra, Mahavir Chakra, Kirti Chakra, Veer Chakra, Shaurya Chakra, and President's. Now at 7th, there is a award that is President's Police Medal for Gallantry, President's Gallantry Medal for the Fire Services personnel. This award includes, this award is given to the police forces personnel. Then the 8th is Sena Medal or no Sena Medal or Vayu Sena Medal, then mentioned in dispatches. And then 10th is the Police Medal for Gallantry, Gallantry Medal for Fire Services. So up till this, by the candidates of police personnel are dealt in priority 5 only. For other paramilitary forces, the candidates are allowed under priority 1, 2, 3, 4, and 5. The other priorities of 6, 7, and 8 are only for armed forces, that is Army, Navy, and Indian Air Force. What are those? Wards of ex-servicemen, that is priority 6. Then priority 7 is wives of defense personnel disabled in action and boarded out from service, defense personnel disabled in service and boarded out with disability attributable to military service, and ex-servicemen and serving personnel who are in receipt of gallantry awards. And the 8th is wards of serving personnel. So these are the 8 priorities under which the candidates opting for admission under CW category is to be classified, and they will be admitted. Now, who are the authorities who are competent to issue educational concession certificates under CW category? Secretary, Kendriya Sainik Board, Rajya Sainik or Jilla Sainik Board, Officer in Charge, Records Office, First Class Stipendiary Magistrate, Ministry of Home Affairs, or police personnel in receipt of gallantry. Now, third type of supernumerary seats is foreign nationals. 5% seats in each course and departments, colleges are being filled, or up to 5% admissions are made of foreign nationals. Sports and extracurricular activities for undergraduate courses, up to 5% of total intake in each undergraduate course in sports and ECA, and for postgraduate courses, it is only for sports, and that is up to 5%. Now, ward quota. Ward quota was introduced in the admissions of the undergraduate merit-based courses by an AC resolution in 1996. Last year, the Academic Council, the competent authority of the university, on receiving several representations formed, constituted a committee, which committee recommended certain things. These recommendations were placed before the Academic Council, and the Academic Council in its meeting held on 27th November 2020 wide its resolution number 9 approved what it approved. The council considered the recommendations of the committee constituted by the competent authority with regard to enhancement of seat for admission under ward quota. The council resolved that the wards of the employees teaching, non-teaching on roles and superannuated, temporary, ad hoc, contractual with 3 years of service of the University of Delhi and its colleges in various undergraduate, postgraduate and professional courses subject to the approval of the concerned professional bodies as applicable, if any, in the university departments and its college shall be in the order of preference as under permanent staff, teaching and non-teaching, retired staff, teaching and non-teaching, temporary, ad hoc and contractual staff, teaching and non-teaching with 3 years of service. So the major difference that the AC resolution of 2020 made in the ward quota resolution of 1996 is that first, it was extended to postgraduate courses also. Second, it was extended to professional courses also, subject to approval of concerned professional bodies as applicable, if any, and if there is any specific denial by the professional bodies, then only it is not to be introduced. Otherwise, it is to be introduced. The most important thing is in this AAC resolution, this benefit was extended to the retired employees of the university and its colleges, and also the temporary, ad hoc and contractual employees of the university and colleges who have performed or worked in the university or its colleges for a period of 3 years. And the Academic Council also provided a order of preference that the candidates of permanent staff, teaching and non-teaching, will be given first priority. Then the second priority will be given to the candidates of teaching and non-teaching or wards of teaching and non-teaching retired staff. And the third priority would be given the wards of temporary, ad hoc, contractual employees of teaching and non-teaching with 3 years service. So these are the major additions, or you can say amendments in what was earlier extended. The ambit was extended from UG to PG also, and that too in UG entrance-based courses also. And the category of wards of earlier only permanent teachers were and non-teaching staff were eligible. It was extended to retired staff and ad hoc, contractual and temporary staff. Further, one more thing was added, and that was the B part, which for admission of the wards, sons, daughters of the employees of the university, other colleges, teaching, non-teaching, the total number of seats earlier used to be 3. Now it has been increased to 16. That is 8 for teaching and 8 for non-teaching. And all these admissions under ward quota will be in above the sanctioned positions, or that is these admissions are also supernumerary in nature. Last thing that we will discuss about in the admission or the student related activities is span period. Span period is the period during which a candidate admitted in a particular course is allowed to complete that course. Earlier, this span period for undergraduate courses was, for a 3-year course, it was 6 years, and for a 4-year course, it was 8 years. So, in effect, we were having this 2n. If n is the number of years required for a completion of a course, then 2n, or the twice the number of years, is the span period during which a candidate admitted in a particular course can complete his or her course. The UGC notified in 2015 by an letter and said that the university should have all the universities should have a uniform span period within which a student may be allowed to qualify for a degree. And that, what the UGC suggested, as per the guidelines of the UGC, a student may be allowed 2 years period beyond the normal period to clear the backlog to be qualified for the degree. So what the UGC suggested is that 2 years beyond the normal period. That is, if a student has been admitted in a 3-year undergraduate course or a 2-year postgraduate course, he would be allowed 5 years or 4 years to complete the degree. In addition, a further extension of 1 year can be granted under exceptional circumstances to be spelled out clearly by the relevant statutory body of the university. More so, during the extended period, the student shall be considered as a private external candidate and also not eligible for ranking. So, UGC said usually it would be 2 years more than the normal period, and in exceptional circumstances to be defined by the university or the college or the degree awarding institution, you can give 1 more year of extension. But during the extended period, the student shall be considered as a private or external candidate, and they would not be allowed to be part of the ranking, overall ranking of the candidates in that particular course. And this provision of UGC was adopted by the AC in its meeting in 2016, and the EC resolution number 11/4 dated 20th February and 7th March 2017. And one thing I would like to share with you all, that the university, considering the current pandemic situation which has been going on since 2020, has used this clause of further extension of 1 year, and some students have been benefited by this provision. So this completes the discussion regarding the admission or the student-centric activities. Though it has not covered all the activities of the students in a college or a university, but these are the activities that come up day to day in a day-to-day manner. Now we will deal with, we will try to discuss some points on rosters. So what is a roster? Roster is a list or plan showing terms of duty or leave for individuals or groups. So roster is not any, roster is a very, anything which we list to do at a certain interval, or whether we are preparing a list of individuals or groups to perform in different way, that is a roster. The colleagues from science departments or working as in the lab or library of the college or university would appreciate that they follow a roster, that some of you might be serving on Mondays, Wednesdays and Fridays, and somebody will be working on Tuesdays, Thursdays, and so that whatever in some from 8 a.m. to 2 p.m. and then 2 p.m. In for that matter, the roster is maintained for the security personnel at different places. How whose duty is from this to this, and so roster is a list or plan showing terms of duty or leave for individuals or groups. But when this roster, this plan pertains to the sanctioned posts of a institution, and that particularly deals with which post is to be reserved or not, then it becomes a reservation roster. So post-based roster, a list maintained showing terms of appointment and promotion for individuals belonging to different categories. So a list which shows that appointment on these posts will be made and whose appointment it will be made, whether the person belonging to the unreserved category or the scheduled caste category or the scheduled tribe category or the OBC category or the EWS category. That is the post-based reservation roster. That document is called post-based reservation roster. Now, what are the government guidelines on reservation regarding roster? Not all the guidelines pertaining to reservations. We are dealing with the roster. So the most important thing is rosters not for determining seniority. So roster is not meant to determine the seniority of the people appointed. How seniority is done, we will deal later. Now, there are two fundamental principles in drawing up rosters. First, reservation shall be kept within the prescribed percentage. That is, whatever the prescribed percentage of reservation is made for a particular category, that is to be maintained. That is to be maintained and that is to be taken care of while preparing the roster. And total reservation in a cadre shall not exceed the prescribed limit. And total reservation in a cadre of post, whether it is assistant professor, section officer, senior assistant, lab attendant, or whatever, the total reservation in that particular cadre should not exceed the prescribed limit. That is, whatever the limit has been prescribed as per the constitution. The number of points in each roster will be equal to the number of points in the cadre. So roster will show the number of points that are the points for that particular cadre. So if a college has 150 positions of assistant professor, so the reservation roster for the assistant post of or cadre of assistant professor in that particular college will have 150 points. This point is more emphasized as size of the roster equal to the cadre strength. So how much posts are there in a particular cadre, that would be the size of the roster for that particular post. Size of the roster equal to cadre strength. Now roster contracted or expanded if cadre strength is decreased or increased. So if the cadre strength or the number of posts in a particular cadre decreases, because the roster will contract, and if it increases, then it will be expanded. So if the number of positions, number of posts an assistant professor is say 110, and during the OBC second tranche or the EWS reservation, the college gets 20 more positions, then your roster will expand to 130. This is what is called contraction and expansion. Now, separate roster shall be maintained for each type of, that is, if the mode of recruitment, direct recruitment, there should be separate roster. For promotion, there should be separate roster. Why this is maintained? Because in direct recruitment, there are the reservation is to be given to the candidates belonging to other backward classes, non-creamy layer and economically weaker section. However, in promotion, only reservation of only scheduled caste and scheduled tribe is permitted. Post filled by transfer or transfer on deputation not to be entered in the roster. So if you are appointed somebody on deputation on any post, then or by transfer, you should not mention that appointment as in the roster. SC, ST, OBC candidates selected on merit will not be shown against the reserved points, but shown against unreserved points. This is important. Any person belonging to any category, if he or she has been selected on his or her own merit, is to be treated as and plotted at unreserved points, not at the points reserved for that particular category. So in direct recruitment, these are the percentages and points of reservation in a 200-point roster. SC 15%, 30 points, ST 7.5%, 15 points, OBC 27%, 54 points, EWS 10%, 20 points. Reservation in promotion, the same as prescribed for 200-point roster for all India recruitment by open competition. Out of 200 points, reservation will be scheduled caste 15%, 30 points, 7.5%, 15 points. No reservation for OBCs in promotion and no reservation for EWS in promotion. So remaining 155 points will be unreserved. Now, as per the RPD Act 2016, the person there is a provision of reservation for persons with benchmark disabilities, that is 4% of total number of vacancies to be filled up by direct recruitment. And this also is due only in direct recruitment for Group A positions. Against the post identified for each disabilities, 1% each shall be reserved for persons with benchmark disabilities under blindness and low vision, deaf and hard of hearing, locomotor disability including cerebral palsy, leprosy, cured, dwarfism, acid attack victims and muscular dystrophy, and 1% under autism, intellectual disability, specific learning disability and mental illness, multiple disabilities from amongst persons under clauses A to D including deaf blindness. So out of 4%, 3%, 1 for blindness and low vision, 1 for deaf and hard of hearing, and 1 for locomotor disability, and 1% under autism and combined. So this is the 4% reservation that is to be extended for persons with benchmark disabilities. Now we come to the third aspect after roster. What we come is how a person is recruited or induction in service. We dealt with the students, then we dealt with rosters, which is part of the personnel or the persons who are working in the in the university or the college, whether they are teaching or non-teaching. So there are two modes of persons to be inducted in service. One is direct recruitment, the other is promotion. In promotion, there are two types of promotion. One is seniority cum fitness, that is in which a minimum time period is required to be to work as a particular post, and when you have completed that time period and as per your seniority, you will be promoted to the next higher post. The other is limited departmental examination, LDE, or speed up promotion, where a person with not the prescribed time period, less time period, but in this case, they don't get promotion based on their seniority or fitness. They have to appear in an examination, and after clearing that examination, they can be promoted. So promotion, there is seniority cum fitness, and the other part is limited departmental examination. In direct recruitment, we have to decide about recruitment rules. So any institution who wish to appoint persons needs to have a recruitment rule. What are the recruitment rules? Rules for post prescribing inter alia the method of recruitment and eligibility for such recruitment. The rules which describe how a post is to be filled or how recruitment is to be done on that particular post and what are the eligibility criteria for that particular post. These are recruitment rules. Any recruitment rule has two parts. One is notification part and the schedule part. And these are statutory in nature and comes into effect prospectively. So any eligibility or the recruitment rule once framed will come into effect from that particular date, not prior to that. In terms of the University of Delhi, the recruitment rules for non-teaching employees, the current prevailing recruitment rule non-teaching employees 2020 is that the Executive Council of the University in exercise of powers conferred under Statute 622 and Ordinance 12D has prepared this, which was approved by the Executive Council and it has come into effect. Why we have made this recruitment rule? For regulating the method of recruitment to non-teaching posts in the University of Delhi, its colleges and matters related thereto. So we have prepared this recruitment rule for what? To regulate the method of recruitment on non-teaching posts and of the university and its colleges and other matters related to it. In case of teaching, we don't specifically have a specific recruitment rule specific to the University of Delhi. What we follow is UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for the maintenance of standards in higher education 2018. The recent one is UGC, in short, we call it UGC regulations 2018. Earlier, it was UGC regulations 2010. So once the UGC issues these regulations, these are adopted by the university and necessary amendments are made in the various statutes, ordinances of the university. Or what are those amendments? Statute 19 deals with the selection committee, the composition of the selection committee for the appointment of teachers in the departments of the university. So if there is any change in the composition of the selection committee in the UGC regulations, the Statute 19 needs to be amended, and after the issuance of UGC regulation 2018, we have amended our Statute 19. The selection committee for appointment of assistant professors in colleges is defined in the Ordinance 18 of the ordinances of the university, and accordingly, and the minimum qualifications and other regulations, conditions which are part of the UGC regulations are adopted in the Ordinance 24 of the ordinances of the university. Now, promotion. Why promotion? We do promotion to advance an employee's rank or position in a hierarchical structure, allows to take on new responsibilities and tasks that challenge an individual to grow in career, advancement in salary, higher job title, and promotion is a kind of motivation for working. So, as discussed earlier, there are two ways of promotion. One is departmental promotion committee, where seniority come fitness. How this is done? To be earned by dint of hard work, good conduct, and result-oriented performances as reflected in APARs. That is annual performance appraisal reports. And the other point is limited departmental examination. Now, Department Promotion Committee, DPC, is defined and it is mentioned the size and composition of DPC as mentioned in recruitment rules. So the recruitment rules in case of University of Delhi and its colleges have mentioned in their appendix the composition of DPCs for each post. And as the promotions of non-teaching staff is going on in the colleges and the university, the DPC meetings are being held. What are the papers that the college which is organizing the DPC or the university ones or anybody who is organizing the departmental meeting of the departmental promotion committee, they need to put up the following papers before the DPC so that the work of the DPC is eased out. What is seniority list, then apart, then recruitment rule, list of eligible persons, who all are eligible. Then what are the vacancies, and roster, what are the vacancies available and under which category those vacancies are available. That needs to be placed before the DPC, and vigilance certificate in case of the eligible persons, whether they are eligible, which as per the vigilance, they have vigilance clearance to be promoted. Now we come to the next part, that is seniority. As we discussed that in DOPT, in Departmental Promotion Committee or the promotion, one important aspect of promotion is seniority cum fitness. So seniority is an issue which comes up, which needs to be dealt by the college and university. So how seniority is to be decided, we will discuss some aspects here. To be determined by the order of merit indicated at the time of initial appointment. So seniority as per DOPT OM dated 4/11/1992. What DOPT OM says that seniority is to be determined by the order of merit indicated at the time of initial appointment. The time of initial appointment, whatever is the order of merit, that determines the seniority. So in direct recruitment, the relative seniority of all direct recruits is determined by the order of merit in which they are selected for such appointment on the recommendations of the UPSC or other selecting authority. So since the DOPTOM covers the government, so they have mentioned UPSC, but in all, we also follow this. The relative seniority of all direct recruits is determined by the order of merit in which they are selected. Now, person appointed by earlier selection will be senior to those appointed as a result of subsequent selection. How seniority is made on the promotion? Promotions made on the basis of selection by a departmental promotion committee. Seniority for such promotion by the committee. So, if DPC is done, then the seniority is based on the DPC. Promotions made on seniority same as relative seniority in the lower grade. In seniority cum fitness, when you are promoting somebody, they are carrying their seniority from their lower grade and which will be continued in the promoted grade also. If a person is considered unfit in a particular by the DPC, then he is superseded by the junior, then his seniority will, the junior will become senior and the seniority of the senior will come down. And on subsequent promotion of earlier unfit candidates, seniority will not be restored. So it is not that one DPC in the year 2021 found a person who is senior unfit and promotes the junior, and in 2022 the unfit person becomes fit for promotion and he is promoted, and then he claims that his seniority be restored. So there is no provision of restoring that seniority. Relative seniority, there are certain cases in which you have on a particular post, you have some in a particular cadre, some posts are filled by direct recruit and some posts are filled by promotion. So how to determine the relative seniority of direct recruits and promotees determined according to the rotation of vacancies between the direct recruits and promotees based on the quota of vacancies reserved for direct recruitment and promotion respectively in recruitment rules. So however, whatever the recruitment rule prescribes, based on that, the quota of vacancies is determined, and the rotation of vacancies, based on rotation of vacancies, the relative seniority is prepared. If adequate number of direct recruits not available in any year, rotation of quotas would take place only to the extent of available direct recruits and the promotees. If there are not all the posts are filled in a particular year, so how the people who are appointed, the rotation of quotas will be based on, will consider only those who are appointed. To the extent direct recruits not available, the promotees will be bunched together at the bottom of seniority list below the last position, up to which seniority determined on the basis of rotation of quotas. If direct recruits have not been recruited, then the promotees will be bunched together. So there is an example which will clear how this rotation of works. Recruitment rule provides 50% through promotion and 50% by direct recruitment. 10 vacancies arising each in year 2020 and 2021. 2 vacancies under direct recruitment could not be filled in 2020 but filled in 2021. And 2 vacancies under direct recruitment could not be filled in 2020 but filled in 2021. Seniority will be this. Promotee will be first, then direct recruitee, then promotee, then direct recruitee, then promotee, then direct recruitee, then promotee, and promotee. So 10 vacancies were there and 2 vacancies were not filled. So after the third direct recruitee is placed in the seniority, the promotees number 4 and 5 are bunched together. And but in 2021, when the promotion is done for 5 people and the 2 subsequent vacancies of direct recruitments are filled in 2021, the seniority will be like this. Now, this, whatever we dealt with earlier, was the seniority of non-teaching staff. Now, once we are dealing with the seniority of teaching staff, so what are the provisions? The UGC regulation 2018 has a clause 16.3 which says inter se seniority between the direct recruited and teachers promoted under CAS. So clause 16.3 deals with the inter se seniority between direct recruited and teachers promoted under CAS. And what it says, the inter se seniority of a direct recruit shall be determined with reference to the date of joining, and for the teachers promoted under this CAS with reference to the date of eligibility as indicated in the recommendations of the selection committee of the respective candidates. The rules and regulations of the respective central state government shall apply for all other matters of seniority. So this says that in case of direct recruitee, the seniority will be determined with reference to the date of joining, and for the teachers promoted under CAS, it will be as indicated in the recommendations of the selection committee. Now, specifically for University of Delhi, we have provisions under Statute 37 and Ordinance 11, which deals with seniority. What Statute 37 says, whenever in accordance with these statutes, any person is to hold an office or to be a member of any authority of the university by rotation, according to seniority, such seniority shall be determined according to the length of continuous service of such person in his grade or post, as the case may be, in accordance with such other principles as the Executive Council may from time to time prescribe. So what it says, that is the length of continuous service of such person in his grade or post. Now what the provision of 37(2), seniority to be prepared and maintained in respect of each class of persons to whom the provisions of this statute apply in accordance with the provisions of the foregoing clause. Now, Statute 37(3) is there. If two or more persons have equal length of continuous service in a particular grade or post, or the relative seniority of any person or persons is otherwise in doubt, the registrar may on his own motion and shall, at the request of any such person, submit the matter to the Executive Council, whose decision thereof shall be final. So Statute 37 says that the seniority is to be prepared based on the length of service in a particular grade, and if there is any dispute, the Executive Council may decide. Now, there is some provision in clause 11 of Ordinance 11 also, which deals with the seniority. That is, the seniority of a teacher in a particular discipline for membership of the committee of courses of departmental committees and such similar committees shall be determined in accordance with following principles. How it is to be decided? Where two or more teachers are selected at the same time for appointment, then according to the ranking given by the selection committee, provided that the date of joining in case of the teacher who has been ranked higher is not later than 3 months from the date of issue of the appointment letter to him. So seniority will be as per the ranking given by the selection committee. That too, provided that the joining is within 3 months period. Where no ranking has been indicated by the selection committee and two or more teachers join on one and the same date, in case such teachers are appointed from a lower post to a higher post, then according to their seniority, inter se in the immediate lower cadre, and in any other case according to the age of the persons joining, the old person being deemed senior. Save in the cases covered by sub clauses 1 and 2 according to the date of joining of the teacher concerned. So either it is date of joining or the age or the seniority in the immediate lower cadre. Now we have dealt with the seniority. Now we come to leave. What are the leave rules that we deal in university and colleges? So first is why leave? To disburse any personal or professional obligation in addition to one's duties. So the provision of leave is made in order to help the individual to disburse its personal or sometimes professional obligation in addition to what the duties and responsibilities we are discharging. Leaves also gives break to the official and indulge in activity that may relax him. Such breaks enable the employees to rejuvenate their energies and be more productive. So the provision of leave was made. Grant of leave is governed by the provisions of Central Civil Services Leave Rules 1972. The most important thing is leave cannot be claimed as a matter of right. You are entitled to get leave, but it is not as it cannot be claimed as a right. In case of exigencies of public service, leave may be refused or revoked. So the leave granting authority can refuse to grant you leave or even can revoke already granted leave. No alteration in the kind of leave applied and due except at written request of the concerned employee seeking leave. An employee has sought leave and the leave granting authority or the person who is processing the leave feels that the kind of leave that the employee has sought is not available to him or not sufficient balance is available. So he cannot change it on its own. It can be done only at the written request of the person who has sought leave. If a person is dismissed, removed, or has resigned from his position, his claim of leave ceases, that you are not eligible to claim leave. When leave commence and when it will terminate, leave ordinarily begins on the day on which the transfer of charge is effected and ends on the day preceding that on which the charge is resumed. So the day you are going on leave, it will start from that day, and the day you are joining, the day before you are joining, the leave will be terminated. The leave granting authority has the power to commute it retrospectively into leave of different kind on written request received from the employee. Casual leave is not considered as a leave under CCS Leave Rules 1972. Except casual leave, any kind of leave may be granted in combination with or in continuation of any kind of leave. No leave for a continuous period exceeding 5 years. So any person cannot be on leave for a period exceeding continuously for a period exceeding 5 years. Provision of combination of holidays is that we do while applying for leave, we ask for the applicant, and if we ourselves are applying, we say we are prefixing or suffixing Saturday, Sunday, or holiday. There is a provision that we can do that. Now, what are the kinds of leave that are available to an employee? Earned leave, full pay is paid, different for vacation and non-vacation officers. That is different from non-teaching staff and teaching staff. Half pay leave is paid. Half pay is paid, credited twice a year in proportion to period served. Commuted leave, again full pay. Leave not due, half pay or full pay as per the granting authority, debited against the leave which becomes due in future. Extraordinary leave, no pay. Other leaves include maternity leave, that is to the female employees, then paternity leave to male employees of 15 days, maternity leave is of 180 days, then child care leave of 730 days. In child care leave, the second year is at 80%. Earlier it is for first year it is on full pay. Surrogacy leave, adoption leave, academic leave like study leave and sabbatical leave for the teaching faculty, study leave for the entry level position, that is assistant professor, and sabbatical leave for a person, associate professor or professor with 7 years of service. For study leave, 3 years of service is required. Encashment of earned leave is also available during LTC up to 10 days at a time of availing LTC and 6 times in the career. Also, encashment of earned leave is allowed at the time of superannuation if the employee dies or he becomes invalidated. Now we discuss what are the some points pertaining to leave travel concession. Any employee with 1 year of continuous service on the date of journey performed is eligible for leave travel concession. And who else is covered under LTC? LTC will cover the government servant and his family. Now, what is the family as per LTC provisions? The government servant's wife or husband and 2 surviving unmarried children or stepchildren wholly dependent on the government servant, irrespective of whether they are residing with the government servant or not. So the first point, what is the definition of family? The government servant's wife or husband, if the government servant is a female employee, is her husband or wife, and 2 surviving unmarried children or stepchildren wholly dependent on the government servant, irrespective of the fact whether they are residing with the government servant or not. In addition to these, who else are considered family? married daughters divorced, abandoned, or separated from their husbands, and widowed daughters and are residing with the government servant and wholly dependent on the government servant. So married daughters are also considered family subject to certain conditions. Parents and or step parents wholly dependent on the government servant, whether residing with the government servant or not. Parents are also considered family if they are wholly dependent on you, whether irrespective of the fact whether they reside with you or not. Unmarried minor brothers as well as unmarried, divorced, abandoned, or separated from their husbands and widowed sisters residing with and wholly dependent on the government servant. Unmarried minor brothers and unmarried sisters with certain conditions are also considered family, subject to the fact that they are residing with the government servant, are wholly dependent on the government servant, and the most important thing is provided their parents are either not alive or are themselves dependent on the government servant, then only the unmarried minor brothers and sisters can be considered family. The restriction of the concession to only 2 surviving children or stepchildren shall not be applicable in respect of 2 conditions. What are those conditions? First, those employees who already have more than 2 children prior to 20 October 1998. So 20 October 1998 से पहले, those employees who already have more than 2 children, all the children will be considered family. And where the number of children exceeds 2 as a result of second childbirth, resulting in multiple birth. If the second childbirth of the government servant has resulted in multiple births, then all the children will be considered family. Only one wife is included for LTC rules. If a government servant has 2 legally wedded wives and the second marriage is with the specific permission of the government, the second wife shall also be included in the family. Not necessary for family to reside with the government servant so as to be eligible for concession. It is not necessary for the family to be residing with the government servant. Children of sisters who are divorced, abandoned, separated from their husbands or widowed are not included in the term family. We discussed earlier that the divorced, abandoned, separated from their husband or widowed sister can be included in the family, but the children of such sisters will not be included. And what this dependent means, a member of the family whose income from all sources does not exceed the amount of minimum family pension, that is rupees 9,000 per month, and dearness relief thereon is deemed to be wholly dependent. So any income which is less than the minimum family pension, that is 9,000 rupees per month and dearness relief thereon, that is the criteria for a person to be considered wholly dependent of the government servant. And condition of dependency not applicable on the husband and wife. If both are working, then this dependency condition of 9,000 rupees per month plus dearness relief will not be imposed on husband or wife. They are treated as one unit for the purpose of LPC. What are other salient points in leave travel concession? Hometown, that is every government servant will declare one and accepted by the controlling officer, and during the entire service one time you can change your declared hometown. When both husband and wife are government servants, they can declare separate hometowns independently, can claim LTC for their respective families. Either of the parent can claim the concession for the children in a particular block. Husband or wife who avails LTC as a member of the family of the spouse cannot claim independently for self. So either of the parent can claim the concession for the children, that is there, but husband or wife who avails LTC as a member of the family cannot claim independently for self. Government servant shall declare the place of visit before commencement of the journey to avail All India LTC. In case a person is willing to avail the All India LTC, he has to declare the place of visit before the commencement of his journey or her journey. LTC can be availed during any period of leave, including casual leave and special casual leave, but not during weekend holidays without availing any leave. So you can combine weekend holidays, but you have to avail one leave. Class of journey will be as per the entitlement of the government servant. Whatever is the entitlement of the employee, that will be the class of journey permitted. Reimbursement of outward journey only is permitted provided government servant forgoes concession for the return journey. If a person wants to reimburse only the outward journey, not the inward journey, it is permitted. Reimbursement of return journey only is permitted. Similarly, return journey can be permitted. LTC can be combined with transfer and tour. If an official is under suspension, he cannot claim LTC, but his family can. So if a government servant is suspended, he cannot claim LTC, but his family can claim LTC. LTC to hometown admissible irrespective of distance between headquarter and hometown. If the hometown and the headquarter is of the same city, then it is not permitted. Otherwise, irrespective of the distance between headquarter and hometown. LTC to hometown is admissible once in a block of 2 calendar years. If family lives away from headquarters, employee can avail this concession for himself every year in lieu of all concessions. And if, as I already said, if headquarters and hometown are same, not eligible for hometown LTC. LTC to any place in India, admissible in lieu of one of the 2 concessions to hometown in a block of 4 years. Present block is 2018-21. Officials availing LTC to hometown for self alone every year are not entitled to LTC to any place in India. In case of fresh recruit, there are certain entitlements. What are these? Allowed to travel to their hometown on 3 occasions in a block of 4 years and to any place in India on the 4th occasion. This facility available for the first 2 block of 4 years after joining government for the first time. First 2 blocks will apply with reference to the initial date of joining. On completion of 8 years, treated at par with other regular employees. No carryover of LTC is allowed. Now, we come to disciplinary matters. So, what we are going to deal in disciplinary matters today is what are the minor penalties, what are the major penalties, and the procedure for imposing penalty. So, minor penalty include censure, withholding of promotions, recovery from pay of the whole or part of any pecuniary loss to government caused by the official's negligence or breach of orders, reduction to a lower stage in the time scale of pay by 1 stage for a period not exceeding 3 years without cumulative effect and not adversely affecting his pension, withholding of future increments of pay. Now, what are the major penalties? Reduction to a lower stage in the time scale of pay other than as prescribed in minor penalty. Reduction to a lower time scale of pay, grade, post, or service for a period to be specified in the order of penalty. order should also specify as to whether the period of reduction will have the effect of postponing future increments, and if so, to what extent. Whether the government servant will regain his original seniority in the higher grade or post, compulsory retirement, removal from service, dismissal from service. When inquiry is mandatory, if the disciplinary authority has decided to impose any of the major penalties that we discussed, inquiry is mandatory. You cannot impose major penalty on a government servant without an inquiry. In minor penalty also, there are provisions that you can hold an inquiry. In minor penalty, after representation, if it is proposed to withhold increment for a period exceeding 3 years, to withhold increment with cumulative effect for any period, or to withhold increment which is likely to affect adversely the pension admissible to the official, then also the inquiry is mandatory. Even if the disciplinary authority has decided to impose minor penalty, but the penalty that is to be imposed is either withholding increment for a period exceeding 3 years, withholding increment with cumulative effect for any period, or withholding increment which is likely to affect adversely the pension admissible, then inquiry is mandatory. Apart from these provisions, when the disciplinary authority decides that an inquiry should be held, even though proceedings have been initiated for imposition of minor penalties only, you can have the mandatory inquiry. So it is the disciplinary authority which decides whether to impose penalty based on inquiry or not. But if the imposition it is decided that the imposition is of major penalty, then inquiry is mandatory. In minor penalty also, if withholding of increment is required for 3 years, or with cumulative effect or adversely affecting pension, then only inquiry is mandatory. Either way, even if the disciplinary authority is decided to impose a minor penalty, not the 3 that we have discussed, then also if the disciplinary authority so desires, they can hold an inquiry. What is the procedure of imposing major penalties? Charged official served with charge sheet along with a statement of imputations of misconduct and a list of documents and witnesses by which each article or charge is proposed to be sustained. So first thing is that the charged official is to be served with a charge sheet along with a statement of imputation of misconduct and a list of documents and witnesses by which each article of charge is to be sustained. On receipt of article of charge, the employee shall be required to submit his written statement of defense or whether to be heard in person within 15 days, which may be extended to further 15 days at a time, up to a maximum of 45 days from receipt of articles of charge. So, once the charge sheet is issued, the charged official is to reply and submit his written statement, which he has to submit within 45 days. Inquiries must to consider charges refuted by employee. Now, the disciplinary authority has framed 3 or 4 charges against a government servant, and if the government servant has accepted 2 charges, then the inquiry is to be done on the charges which the government servant has refuted. That is, which is denied. If all the charges are accepted, then there is no need for inquiry. Then to appoint an inquiry officer, a presenting officer to be appointed to present the charges. Now, what are the rights of the charged officer or the delinquent official? What is to inspect documents referred to in annexure to the charge sheet, to engage any other serving or retired government servant to assist him. He can take assistance from any serving or retired government servant to engage a legal practitioner if the inquiry officer is a legal practitioner. The charged officer is permitted to engage a legal practitioner if the inquiry officer is a legal practitioner. Sorry. In other cases, the disciplinary authority may permit such an engagement having regard to the circumstances of the case. Even though the inquiry officer is not a legal practitioner, the disciplinary authority on the request of the charged officer may permit him to take assistance of a legal practitioner. If any charge accepted or plead guilty to be recorded by the inquiry officer, proceed within respect of charges refuted, if any. As I earlier discussed, if the charge is accepted, no need for inquiry. Inquiry can be continued in respect of charges denied. Government side has the first priority to present case and produce witnesses and evidence. The government or the college or the university has the first right. Then the delinquent official is allowed to offer his defense witnesses and evidence. The charged officer is permitted to submit his list of witnesses and documents based on which he wants to prove his innocence. Witnesses on both sides be examined, cross-examined and re-examined. The witnesses from the disciplinary authority side and from the charged officer can be examined and cross-examined by the other party and re-examined. Defendant may examine himself as a witness in his own behalf to be examined by the inquiry officer. If the charged officer feels that he needs to be examined, the inquiry officer can examine him. Defense may be in writing or oral. Oral defense to be recorded and signed and supplied to presiding officer. Written brief by presiding officer, copy to delinquent official, delinquent official's written brief to inquiry officer. After completion of the proceedings, the presiding officer will submit a written brief, which will with a copy to the charged officer, who, based on the written brief and other inquiry proceedings, submit his written statement to the inquiry officer. Entire proceedings of the inquiry to be recorded in writing, every page signed, copies to delinquent official and presiding officer. All the proceedings of the inquiry needs to be recorded in writing, and all the pages should be signed by the inquiry officer, the charged officer, the presiding officer, and a copy be sent to the charged officer and the presiding officer. If delinquent official do not attend, ex parte inquiry may be conducted. In case the charged officer is not participating in the or presenting himself in the inquiry committee, the inquiry can be done ex parte. On completion, inquiry officer submits finding on each charges to the disciplinary authority. The role of the inquiry officer is to submit his findings on each charges to the disciplinary authority, and those findings should be contained to whether the charges are proved or not proved. Disciplinary authority may agree or disagree with the findings and make final order. The quantum of punishment is to be decided by the disciplinary authority, and the disciplinary authority, while considering the report of the inquiry officer, may agree with it or may not agree. In case of minor penalties, employee be given copy of charge sheet with a statement of imputations of misconduct, given reasonable time and opportunity to submit his defense. On receipt of defense, the disciplinary authority may pass order or hold inquiry. So in case of minor penalties, first a charge sheet with a statement of imputation of misconduct is served. The charged officer is given reasonable time and opportunity to submit his defense. On receipt of the defense, the disciplinary authority may order to impose minor penalty or hold inquiry. It is of the opinion that such an inquiry is necessary, and the inquiry is mandatory in view of the punishment proposed. So why to hold inquiry? Why the disciplinary authority needs to take a decision to hold inquiry? Because it is of the opinion that such inquiry is necessary, or it is mandatory in view of the penalties or the punishment that is proposed. And the procedure for inquiry would be same as we have discussed for that of major penalties. So thank you. This completes the discussion today. Thank you all for patient hearing.
Thank you, sir, for this comprehensive deliberation on various facets of administration, such as admission, rosters, recruitment, promotion, etc. It was indeed quite insightful, and I'm sure the participants would have had much to take from your lecture. Sir Benjamin Franklin once said, "Tell me and I forget, teach me and I remember, involve me and I learn." So now is the time for the participants to get involved in the discussion by asking questions. So if there are any queries, please post them into the chat box. Ravinder, is this chat box on?
Yes, ma'am, it is on.
You can raise your hands also. अगर किसी ने कुछ पूछना है तो
I believe sir's lecture was already very informative, so nobody has any questions to ask.
Monica, there is one question in the chat. Two questions.
One person, Usha Sati, has raised her hand. Sir, the question from Gagandeep Singh. LTC में एडवांस नहीं दिया जा रहा है क्या आजकल?
There is a provision of advance up to 90% of advance in LTC. नहीं दिया जा रहा है, इसका जवाब देना थोड़ा मुश्किल है, क्योंकि वो स्पेसिफिक केस होगा और वो स्पेसिफिक कॉलेज या स्पेसिफिक डिपार्टमेंट का इशू है. But rule position is that there is a provision of giving advance in case of LTC, and it is up to 90% of your expenditure.
Ms. Usha, you can unmute yourself. Up. Ravinder, can we unmute her? Oh,
Hello.
जी मैडम बताएं.
सर आप सुन पा रहे हैं मुझे? गुड इवनिंग सर. सर मेरे को क्वेश्चन है कि जब हमारी अपॉइंटमेंट होती है टीचिंग एंड नॉन टीचिंग किसी भी पोस्ट में, तो जो हम डिपेंडेंट फैमिली मेंबर्स का जो हम फॉर्म फिल करते हैं और अपने पेरेंट्स का नाम ऐड करते हैं या अपने इन-लॉज का नाम हम ऐड करते हैं, तो उस वक्त भी हमको क्या उनका वो लेना पड़ता है इनकम सर्टिफिकेट जो होता है?
मैडम देखिए, आप अपने फैमिली
का होना चाहिए.
जब आप फैमिली मेंबर्स का नाम देते हैं वो एक रिकॉर्ड हो जाता है.
ओके.
लेकिन जब आप उसमें कुछ
मेडिकल के लिए या फिर एलटीसी वगैरह लेने के लिए लेते हो,
जब आप उसमें आप उनका नाम आपने रिकॉर्ड में दे दिया, जब आप उनके लिए बेनिफिट क्लेम करेंगी यूनिवर्सिटी या कॉलेज से, चाहे वो मेडिकल रिइंबर्समेंट हो, चाहे एलटीसी हो, या एट द टाइम ऑफ सुपरएनुएशन आप उनको अपने पेंशनरी बेनिफिट्स में से कुछ आपको देना है, तो फिर वो डिपेंडेंस का सर्टिफिकेट और डिपेंडेंस एस्टैब्लिश करना पड़ेगा. बिना उसके आपको बेनिफिट्स क्लेम नहीं कर सकती.
ओके. यानी कि जब हम फैमिली डिक्लेरेशन फॉर्म देते हैं उसको हम ये ना माने कि ये उसके लिए बेनिफिट ले सकते हैं. नहीं,
वो जब बेनिफिट आप क्लेम करेंगी तो अगर आपने अपने फैमिली डिक्लेरेशन फॉर्म के साथ वो प्रूफ लगाया है कि दे आर डिपेंडेंट ऑन यू, तब तो कोई दिक्कत नहीं है। लेकिन अगर नहीं लगाया है तो जिस दिन आप एडमिशन बेनिफिट क्लेम करेंगी उस दिन कॉलेज या यूनिवर्सिटी आपसे ये प्रूफ मांग सकती है और आपको देना पड़ेगा।
ओके सर। सर एक क्वेश्चन और है मेरा। हेलो सर
जी।
हाँ सर, एक क्वेश्चन और है। अगर किसी एम्प्लॉय का एक जो बेटा है, डिपेंडेंट है, वो मेंटली रिटायर्ड है या इस तरह का पीडब्ल्यूडी,
उसका भी एक प्रोविजन है। मेंटली रिटार्डेड स्टूडेंट्स को भी हम
बच्चा है तो उसके लिए क्या करना पड़ेगा? मतलब वो हमेशा उनका डिपेंडेंट रहेगा बच्चा?
हाँ हाँ, उसका प्रोविजन है। वो आपको कुछ प्रूफ के साथ देना पड़ेगा तो आप उसको डिपेंडेंट कर सकते हैं।
मतलब उसके साथ क्या, मतलब उसका सर्टिफिकेट जो होता है, पीडब्ल्यूडी का सर्टिफिकेट जो होता है?
हाँ, पीडब्ल्यूडी का सर्टिफिकेट भी होगा और वो ये प्रूफ होगा कि वो परमानेंट डिसेबिलिटी है। और कॉलेज या इंस्टीट्यूशन कैन also get that certificate verified before approving your request.
Okay, sir. Okay. Thank you so much, sir.
Now, there is one question by Pankaj Ji from Shivaji College.
Yes.
Kindly enlighten us about seniority in case of promotions done under CAS 2018.
सर, CAS 2018 के तहत जो प्रमोशंस हुए हैं वो मैंने अपने प्रेजेंटेशन में भी डील किया कि यूजीसी रेगुलेशन ये कहता है कि अगर इंटर से सीनियरिटी बिटवीन डायरेक्ट रिक्रूट एंड प्रमोटी है तो वो डेट ऑफ एलिजिबिलिटी जो सिलेक्शन कमेटी ने डिसाइड की है प्रमोशन के केस में उस दिन से होगी। हमारा ऑर्डिनेंस 11 जो यूनिवर्सिटी का है वो ये कहता है कि अगर आपका प्रमोशन हुआ है और एक ही दिन प्रमोशन हो रहा है तो जो आप लोअर लेवल पे जो सीनियरिटी आपकी है वही आप कैरी फॉरवर्ड करेंगे।
Okay. So there is another question by Mr. Dharmendra Kumar. Sir, आप प्लीज म्यूट कर लीजिए, अनम्यूट कर लीजिए अपने आप को। धर्मेंद्र जी।
कहाँ है अभी? कौन से?
हेलो।
धर्मेंद्र जी आप अनम्यूट हैं प्लीज।
अच्छा लगा बड़ी खुशी की बात है।
I think
Monica, is there any other question?
No, there is no other question. Pankaj ji from Shivaji College ने दोबारा पूछा है, seniority will be decided by the order of merit as indicated at the time of initial appointment.
Yes.
So I don't think so. No, there is no other questions, Vanita.
Okay.
So should we wind up the session?
Yeah.
Okay. Thank you, sir. Thank you once again for being so kind and giving your invaluable time to discuss all these golden rules with the participants. And we hope to hear from you again sometime in the future.
Thank you, ma'am. Thank you.
Thank you, dear participants, for being such a lovely audience. And thank you all. See you tomorrow.